When you think of perjury, you probably think of a dramatic courtroom trial where a witness is caught lying during his or her testimony. This classic portrayal is just one form of perjury. The Texas Penal Code offenses of perjury and aggravated perjury apply to much more than just courtroom testimony. First, perjury is evaluated based on its materiality, or whether or not it is material. Material means a statement that affects or could have affected the course or outcome of an official proceeding. So, for example, the type of shoes a defendant was wearing may or may not be material depending upon the circumstances of the case. If there are footprints at a murder scene, then what the defendant was wearing that night might be very material. If the crime is drug possession, the defendant's footwear might not be material at all. Or how about the color of the defendant's shoes? If the witness saw a woman wearing pink shoes, then the color is very material. If the witness never observed the defendant's shoes, then it's probably not material. The Penal Code specifies it is not a defense to perjury or aggravated perjury the person mistakenly believed their statement to be immaterial. So there is no defense for a person who rationalizes their lie was minor or less serious than it could have been. A defendant who states, "Yes, I lied, but you shouldn't charge me because I thought the lie wasn't material," can't use this as a defense. The Penal Code states a person commits perjury when he or she, with intent to deceive and with knowledge of the statement's meaning, makes a false statement under oath, swears to the truth of a previously given statement when the statement is required by law to be made under oath, or makes a false, unsworn declaration under the Civil Practice and Remedies Code. So, there are three ways to commit perjury. First, to make a false statement under oath. This can be any sort of setting where a person takes an oath and makes or gives a statement. Second, a person can commit perjury if they provide a statement which was not sworn to and then later, after taking a lawfully administered oath, swear it is the truth after the fact. Finally, a person commits perjury if they make a false, unsworn declaration under the Civil Practice and Remedies Code. All of these offenses of perjury are A misdemeanors. According to the Penal Code, aggravated perjury is committed when a person makes a false statement during or in connection with an official proceeding that is material. An official proceeding can be a variety of different settings, including trials, and may also include administrative hearings, such as before a civil service board or a license revocation hearing following a driving while intoxicated arrest. Aggravated perjury is a felony of the third degree. So, for example, a detective who is a witness during a criminal trial, which is consequently under oath and an official proceeding, who intentionally, knowingly, or recklessly lies and says the defendant was wearing high-heeled shoes that match the bloody footprints found at the murder scene, has committed aggravated perjury because this statement is likely material. How do we know this statement is material? More than likely, the lie would affect or could affect the course or outcome of the trial. There is only one defense to aggravated perjury. The Penal Code states it is a defense if the actor retracted his or her false statement before completion of the testimony of the official proceeding and before the falsity of the statement could be exposed. So, essentially, if you commit aggravated perjury, you better fess up to it right away. If you don't admit to your lie before you finish testifying, or before the opposing party's attorney can confront you with the lie, you don't have any chance of offering a defense. According to the Penal Code, if you have made inconsistent statements in either a previous official proceeding or during the same official proceeding, a subsequent information or indictment for perjury or aggravated perjury does not need to specify which of the two statements was the lie. The Penal Code specifies it is not a defense to perjury or aggravated perjury that the oath was administered in an irregular manner. In other words, you can't claim the judge who administered the oath mispronounced a word or forgot a word, or you don't believe in God, or you had your fingers crossed, or anything else of that nature. Finally, it is also not a defense the document which contained the lie was not sworn to when it contained language it was made under oath. So you can't claim, "I never actually stood up, raised my right hand, and repeated an oath out loud" if the paper you signed, initialed, or otherwise acknowledged has something like, "I declare under penalty of perjury this statement is true and correct to the best of my ability," or "subscribed and sworn to me."